Hey guys. So yesterday I did my video on this letter that Library filed, and the video is called Library Files a Protesting Letter regarding the mixed motive defense instruction. That's what it was. Um, so she went into this like 4-page ramble about, kind of like this isn't fair, blah blah blah, that kind of thing, but kind of more professionally wording it. Anyway, and then she filed an attachment, which was the actual jury instruction. Well, Wayfarer have actually filed a response, which I was expecting. It's glorious. Very brief and to the point. Dear Judge Liman, defendants Wayfarer Studios, It Ends With Us movie and tag submit this letter in response to plaintiff Blake Lively's unexpected April 29th, 2026 letter brief and proposed jury instruction for defendants' mixed motive or same decision defense. Plaintiff's letter brief re-argues and effectively seeks reconsideration of the court's April 28th, 2026 order denying plaintiffs' request to preclude defendants from presenting a same decision defense. And I said that in my video. I was like, it sounds like a motion for reconsideration without saying expressly, Judge, can you reconsider this? Like, it was almost like, I mean, it could have also been dressed up as a motion for summary judgment, to be fair. That was the kind of language that was being used in it. The judge had already ruled on this and denied her request to basically exclude this defense. He denied it already, but she was still like, yeah, but Judge, that's so not fair, kind of thing. So Wayfarer continues. First, plaintiff does not meet the standard for relief under Federal Rule of Civil Procedure 60B. Rule 60 permits reconsideration where, among other things, an order is the product of a mistake, inadvertence, surprise, excusable neglect, or fraud, or there is newly discovered evidence that could not have been discovered prior to the entry of the order. Lively has made no such showing. Accordingly, the court should decline plaintiff's invitation to reconsider its order. Second, as part of their pre-trial submissions, defendants proposed a same decision jury instruction patterned on Judicial Council of California Advisory Committee instruction. Plaintiff declined to provide her own proposed jury instruction on a same decision defense on the ground that the defense had been waived. Yeah, so I went back through when I did that same video. Actually, I went through the actual jury instructions to compare Wayfarer's jury instruction for this defense to the one Lively was now proposing. And I said at the time, like, oh, she's not actually submitted anything at that point in time, because she was like, no, well, it's been waived, so I don't need to respond to this. Following the court's rejection of plaintiff's waiver argument, plaintiff now submits a proposed jury instruction on same defense that substantially modifies the standard CACI instruction. The proposed instruction is improper. The initial paragraph encapsulates Lively's theory of the case by instructing the jury that Lively need not engage in any protected activity to hold defendants liable for retaliation, and that defendants' factually baseless retaliatory lawsuit, threats, and/or attempts to intimidate Lively and third parties and attacks on Lively's reputation through a media campaign constitute adverse employment actions. Yeah, absolutely. Her instruction was just completely unreasonable. Thus, the proposed instruction directs the jury to assume ultimate issues of facts based on incorrect statements of law and should be disregarded. That's from the lovely Ellen. Yeah, 100%. In fact, I just very briefly. I mean, look at this, right? It's quite a long-winded instruction. This is the actual instruction Lively's proposing, and basically, it goes over the allegations, that she was subjected to an adverse employment action by discouraging and obstructing her ability to complain. And again, I question that, because nothing stopped her or obstructed her from complaining. She complained. She went to Alex Sachs. She went to Ange Giannetti. She had her attorney, draft that 17-point protection letter. There was all of those things. And in the end, she filed a CRD and a lawsuit. So nothing stopped her. She could have gone to SAG-AFTRA as well. There were other avenues that she could have gone down. Nothing stopped her. Attacking her character and professional reputation, threatening and or attempting to intimidate her and third parties. Again, third parties. Who are these third parties? How did Wayfarer, threaten or attempt to intimidate? You can't just stick that in there, because they're now no longer going to be proving this. So she's not going to be proving it, and Wayfarer that by extension will not be defending it. So to just wallop that into in a jury instruction with no context, which is very on brand for Lively, would be incredibly damaging and prejudicial to Wayfarer. And then she says, filing a frivolous and factually baseless retaliatory lawsuit against her because there's no need for that. The jury instruction is supposed to be simple. What's the best way I can describe this? So what this is going to look like now, right, is when it comes to arguments, is Lively is going to say, Wayfarer retaliated against me because I engaged in protected activity, right? And she's trying to litigate that in this instruction. This is not what that's for. What Wayfarer can now do as a result of Judge Liman allowing this defense is say, hey, actually, no, we were just protecting the studio. And what I would expect Wayfarer to do if I was their attorney is I would then bring out the recording of Steve Sauerwitz, the one Claire Ayub recorded, because Steve Sauerwitz, right, and this is done in real time in August 2024, the retaliation period is literally in the middle of it all. Steve Sauerwitz is saying, I will protect the studio. He, at no point, despite Lively's mischaracterization when she quotes it, at no point does he say he's going to destroy Lively or Reynolds or anyone else associated with her. He says he's prepared to spend $100 million. But he's talking about, defending a lawsuit. And he even goes as far as to say, but I don't think it's going to get that far. So he's mitigating any potential threat that Lively is, trying to say that he's making. Because he's literally saying to someone, look, if I have to, I've got a lot of money I can spend. I'll defend my studio, defend myself, defend Baldoni and Heath. And so on and so forth. And then he goes on to say, but I don't think we have to. And I think that recording is incredibly damaging for Lively, actually. I mean, aside from the fact that it was an illegal recording anyway, something that Lively is blowing hot air about, certain Wayfarer parties doing to others. She's submitted this as evidence, and all it does now is completely cement that mixed motive defense, because Steve Sauerwitz is categorically saying to someone completely unconnected to Lively, right? He's not suspecting this person is going to run back to Lively, and he is making it categorically clear that if he has to take any action, it will be to defend the studio, to protect the film. And that's the same decision defense there with evidence. And Lively's not going to be able to say, oh, well, that's not true. She can't even try and spin it that the threat was intended to harm her, because he makes it very clear that that's not what he intends to do. And Judge Liman has obviously, in his motion for summary judgment order on the 2nd of April, made it clear that, the Wayfarer parties were entitled to defend themselves. So, make of that what you will. But yeah, so again, I give flowers to Ellen for this wonderful letter. And it's just not a great week for Blake Lively, is it?